Judgment in the matters of the King on the application of Afzal and the King on the application of Iyieke against the Secretary of State for the Home Department.
There are two appeals before the court in this case. They are concerned with the meaning and effect of the immigration rules and the Immigration Health Charge Order 2015. Paragraph 276B of the immigration rules gives a right to be granted indefinite leave to remain in the UK, which I will call ILR, where someone has accumulated 10 years of continuous lawful residence here. Lawful residence means residence with valid leave to remain. The appeals raise technical legal issues about how one calculates a period of lawful residence when looking to see whether an applicant can show that they have the necessary unbroken period of 10 years. The Immigration Health Charge Order imposes a charge on an immigrant who seeks leave to remain as a contribution to providing them with NHS care while they are in the UK. Section 3C of the Immigration Act 1971 provides for an extension of leave to remain in the UK if someone makes an application for a fresh period of leave before their original leave to remain expires, in order to allow them to continue to be here while their application is determined by the Secretary of State. Mr. Afzal applied for ILR in 2020 on the basis that he had resided in the UK for 10 years by that time. The Secretary of State refused this application. There were two problems with it. First, the Secretary of State said that there was a break in the continuity of his lawful residence in that period. Mr. Afzal had originally been granted leave to remain until the 14th of July 2017. Before the expiry of that leave, Mr. Afzal submitted an application for further leave to remain, along with an application for waiver of the relevant fee. However, the fee waiver application was rejected, and he was notified that he had to pay the fee and the immigration health surcharge as required by the 2015 order. He was given 10 days in which to do this. Mr. Afzal paid the application fee, but not the health surcharge amount. Because that was not paid, the Secretary of State rejected his application for leave to remain. His original leave to remain therefore expired. Later, in February 2018, Mr. Afzal made a fresh application for further leave to remain, accompanied by the relevant fee and the health surcharge amount. And on the 5th of September 2019, he was granted leave to remain until March 2022. On the 28th of February 2020, having resided in the UK for more than 10 years, Mr. Afzal applied for ILR pursuant to paragraph 276B of the immigration rules. He relied on Section 3C of the 1971 Act, which he said extended his original leave until he was granted a new period of leave from the 5th of September 2019. On that basis, he said he had been continuously resident with leave for a period of 10 years, as required to give him an entitlement to ILR under the immigration rules. However, the Secretary of State did not agree. She said that there was a break in his period of lawful residence between 14th July 2017, when his original period of leave expired, and 5th September 2019, when he was granted a new period of leave. She said that Section 3C did not assist him to bridge that gap. The second problem was that, in order to show that he had a period of 10 years continuous lawful residence, Mr. Afzal had to add the period between July 2017 and September 2019 to the periods of leave on either side of it. Mr. Afzal said he could do that because paragraph 276B, subparagraph 5, said that if Section 3C applied, any gap period covered by it was to be disregarded. Mr. Afzal said that this meant he could rely on the gap period to contribute to the required 10 years continuous residence, and all that was to be disregarded was the unlawfulness in that period. The Secretary of State disagreed. She said that the rule meant that one could ignore the gap in continuity, but could not positively count the period as contributing to the 10 years of lawful residence required. If Mr. Afzal could not count the gap period, his periods of lawful residence on either side did not add up to 10 years, so he had no entitlement to ILR under the rule. In the Court of Appeal, the Secretary of State succeeded on both these points. Therefore, Mr. Afzal has appealed to this court. Mr. Iyieke's case raises a different issue about the proper interpretation of paragraph 276b, subparagraph 5 of the immigration rules. Mr. Iyieke was granted a period of leave to remain, but did not apply to extend it before it expired. Therefore, on the 10th of August 2014, he became an overstayer without leave. He submitted an out-of-time application on the 2nd of September 2014 for leave to remain on compassionate grounds, which was refused. On the 26th of February 2015, he submitted an application for leave to remain on grounds of family and private life, which was also initially refused, but the upper tribunal allowed his appeal. As a result, he was granted leave to remain until the 11th of February 2020, and then, as a result of an application to extend that leave, until the 30th of July 2022. On the 17th of February 2021, having been resident for more than 10 years in the UK, Mr. Iyieke applied for ILR pursuant to paragraph 276b of the immigration rules. His application was refused. The Secretary of State pointed out that there was a gap of 111 days between the expiry of his first period of leave to remain on the 9th of August 2014 and the date of the commencement of Mr. Iyieke's second period of leave to remain. She said that this meant that he could not show that he had the necessary period of continuous leave to remain. Mr. Iyieke maintained that on a proper interpretation of paragraph 276b, he was allowed to bridge that gap. He said that he had made a fresh application, being the application of the 2nd of September 2014, within the period of time after the expiry of his leave on the 9th of August 2014, which was stipulated in another provision of the immigration rules, paragraph 39E, to which paragraph 276b referred. However, the Secretary of State said that for the operation of that rule, the fresh application referred to had to be an application that was successful, not one that failed, as Mr. Iyieke's application of the 2nd of September had failed. In this case, the Court of Appeal agreed with the Secretary of State's interpretation of the rule, and therefore Mr. Iyieke has appealed to this court. This court unanimously dismisses both appeals. So far as concerns the first issue in Mr. Afzal's case, the court holds that the answer is given by Article 6 of the 2015 order. That requires the Secretary of State to treat an application for leave to remain as invalid if the immigration health surcharge is not paid within the grace period of 10 days allowed by that provision. It was established in a previous decision of the Supreme Court in a case called Mirza that Section 3C of the 1971 Act only operates to extend leave where a valid application for fresh leave to remain has been made. Once Mr. Afzal failed to pay the health surcharge within the grace period, his application had to be treated as invalid and Section 3C had no application. This meant that he could not bridge the gap in the continuity of his period of lawful residence, as he needed to do in order to succeed in his claim for ILR under the immigration rules. This court also agrees with the decision of the Court of Appeal in the second issue in his case. The natural meaning of the word disregarded in paragraph 276b, subparagraph 5 of the immigration rule is that the gap in continuous lawful residence would be ignored, not that the gap period would positively count towards making up the 10 years of lawful residence which is required under the rule. So far as concerns Mr. Iyieke's appeal, this court agrees with the decision of the Court of Appeal in his case. The proper interpretation of paragraphs 39E and 276b of the immigration rules is that a gap in continuous lawful residence can only be disregarded if the new application for a fresh period of leave, which is made within the specified time from the expiry of the old period of leave, is itself a successful application. The rule does not apply if the new application is one which, though made within the specified time, is unsuccessful. For these reasons, both these appeals are dismissed. The court will now adjourn.